Can I just say something about Andrea?
Welcome back, folks. We're going to be watching part 2 of the Robert Devine decertification hearing. In part 1, we heard the opening statements and the testimony of Stoughton Police Chief Donna McNamara. So we got a little bit of the lay of the land as far as what are the grounds for decertification and what is the defense coalescing around. So to summarize, the basis for the decertification is that Robert Devine is alleged to have committed multiple acts of police misconduct that is substantiated in multiple internal affairs reports, investigations that resulted in findings not favorable to him. And so the first one was from 2015 when he is alleged to have allowed his personal life to interfere with his ability to perform his work. He was having an extramarital affair and used police resources to essentially like scare the woman off. She was ultimately arrested and prosecuted based on his directing subordinates to engage in an investigation against her. He was also found to have been dishonest during that investigation. So as a result of the 2015 IA process, he was demoted back to patrol from deputy chief, and he also received a 60-day suspension. Then in 2021, he was the subject of a second IA investigation involving his conduct towards Sandra Birchmore. At that time, though, he retired before the IA investigation was complete, so he did not ultimately participate in it to its conclusion. Devine is alleging essentially that the process was unfair. He's not disputing the 2015 findings, but he is contending that the 2021 finding is inappropriate, incorrect, that it was not him that apparently communicated with Sandra Birchmore over WhatsApp, Facebook, Snapchat, possibly SMS, possibly email. Like he's claiming to have experienced a long history of internet issues that he is apparently attributing to these communications to that. Not quite clear on what the details of that is, but I got to say that's quite an outage if that's the case. There are also apparently emails from Sandra Birchmore's account that are attributed to they're with somebody named Rob, and he has claimed or implied at least that this is potentially another police officer, but Chief McNamara told us that that officer is known as Bobby, whereas Mr. Devine is the only one who is known as Rob. So that's been our background. The defense lawyer is really freaking obnoxious. Okay, really super annoying, just bad tone, taking up a lot of time, really just obnoxious, questioning, repetitive. Ugh. So you're going to probably catch me cringing more than a few times as we listen through this next bit. But yeah, we'll just soldier through it. So let's go ahead and see what they have for us.
All right. Would you say your name, please?
Brian Holmes.
Right. You raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth in these proceedings.
I do.
Thank you, ma'am. See.
Okay, so Brian Holmes is the IA investigator. He is the one that was the subordinate to Chief McNamara, and he was assigned the 2021 investigation of Officer Devine. Officer Devine is claiming that he is biased because their relationship was damaged after this 2015 investigation because Mr. Holmes doesn't approve of marital infidelity. Who knew? And so according to at least the implication we're getting from Mr. Devine, that they think that that made him biased. Chief McNamara testified that as far as she knew, they had kind of talked it out and were able to work together on a professional level. There wasn't any kind of spillover to the professional environment. So I expect that is going to be fleshed out a bit more over the course of Mr. Holmes's testimony.
About the protective order?
Yeah.
Yes. Mr. Holmes, are you aware that there was protective orders that have been issued in this case?
No.
There are, and it's incumbent upon you, and I'm going to make sure that before you leave here today, that you have copies of them. You can show them, Mr. Martinez.
I can email
All right.
afterwards.
Because you need to abide by those. And that is that you not communicate or disseminate any information relative to this case to the public or anybody else. Unless you're required to appear and testify. All right?
Yes, sir.
All right. Mr. Martinez.
Good afternoon.
Good afternoon.
Before we get started, just as an initial matter, if I refer to an individual by the initials SB, do you know who I'm referring to?
Yes.
And when you testify, we ask that you use her initials rather than her full name.
Okay.
What's your current position?
Chief of Police, Town of Kingston.
How long have you been with Kingston?
For 14 months.
Have you been the chief the entire time?
Yes.
Prior to working in Kingston, where did you work?
Town of Stoughton Police Department.
How long were you with the Stoughton Police Department?
It was like 27, 28 years, something like that.
Did you begin at the Stoughton Police Department after you graduated from the academy?
No, I began before as a dispatcher.
When did you attend the academy?
1999.
How long were you a dispatcher before that?
2 years.
After you attended the academy, what rank did you enter?
Patrol officer.
What was your highest rank at the Stoughton Police Department?
Deputy chief.
When did you achieve that?
It was, I think it was 2017.
So for approximately how long were you the deputy chief?
About 7 years.
Who preceded you as deputy chief?
Robert Devine.
Was there a vacancy before you took the role?
Yes.
For approximately how long?
I want to say at least a year.
Other than deputy chief and patrol officer, did you hold any other positions at the Stoughton Police Department?
Yes.
What ranks or roles were those?
As a patrol officer, I was a dog handler. I was promoted to sergeant in 2013. Took on mainly administrative roles, but I was still on the street as a patrol supervisor.
When you were the deputy chief of the Stoughton Police Department, did you conduct internal affairs investigations?
Yes.
And was that the entire time you were deputy chief that you were also conducting those investigations?
Yes.
Any idea on approximate number per year that you conducted?
One year that was really heavy. I want to say it was 2019. A lot of infighting. I think I did 14 of them in a 12-month period. Other than that, the average is probably 6 that I handled directly per year, and some would be delegated out to lower ranks.
What factors led into you delegating out internal affairs investigations?
Some of it would be my own workload. Others, like lower level type internal affairs cases would be handled by a lieutenant, in some cases, a sergeant.
So is it fair to say that you would handle the more serious investigations?
Yes.
Do you know Robert Devine?
Yes.
And how are you know him?
We met at the police academy and we became friends somewhere around 1999.
Well, after following the police academy, what was your personal relationship with Mr. Devine like?
It was highs and lows. I mean, it was, we were good friends for a long time. There was times that I created distance deliberately because of some things that have been going on. And I made the personal choice to, not really have him as a friend. And then it became a superior subordinate type relationship where I was just managing an employee.
And when did that superior subordinate relationship begin?
After I got promoted to deputy chief.
Prior to your promotion to deputy chief,
Excuse me.
outside of the professional world, did you see Mr. Devine socially?
Yes.
And in what types of circumstances?
In the beginning, it was a friendship. It was, family events, birthdays, weddings, different things like that.
Do you have an approximate time to when that social side of the relationship ended?
I'd say probably like 2011, around there. Things got a little bit challenging at times.
Okay, so 2011 is quite a bit before the 2015 IA investigation. So this is a little bit of a different take, I guess, than we got from Chief McNamara and implied from Devine's defense lawyer, because they suggested it was because of infidelity that came out during that previous investigation. So it sounds like his take is no, there were other issues that he had with Mr. Devine on a personal level that made him not want to be friends with him. Took 11, 12, 13 years for the mask to fall, but apparently it did. So he decided he wanted some distance. I don't know that this changes the fundamental aspect of the defense here, that is essentially alleging that he's biased. You stopped being friends with him because you thought he was a bad guy, therefore you didn't conduct a fair investigation. But now I'm interested to hear his explanation for why he didn't want to be friends with Robert Devine anymore. Now, again, remember, this hearing is entirely because Mr. Devine wants to, quote unquote, clear his name. He doesn't want the stigma of the decertification over him. We wouldn't know any of this if he just said, I don't want to be a cop anymore anyway. I'm retired, so who cares? Go ahead and decertify me. But he wants to air all this publicly. So now we're going to hear from this guy why he thinks Mr. Devine was not somebody that he wanted to be friends with.
Were there ever any conflicts in the workplace?
Yes.
And can you briefly go through those conflicts?
Sure. There was a conference that we went to, and he had asked me for feedback on things that might not be going so well. So I took him up on it, had lunch with him, and told him about some things that were kind of lending towards arrogance. There was a former member of the Explorers that had been getting way too cozy. So he and another member of the department had raised the concern and said, you ought to be careful. There was a matter involving him being a cooperating witness for the defense of a guy from the department that had been indicted and tried and convicted. I took sort of a objection to the fact that he did 180 degrees and bailed on being a witness on behalf of the defense. There was hard feelings over it. And it really wasn't a question of right and wrong. It was more a question of moral principle. Just like every once in a while, you get into it. At the point in time, he had transitioned from lieutenant to deputy chief, and the relationship for that time was, superior subordinate at times as well. So just like regular disagreements now and again.
As to the former police explorer you were speaking about, is that somebody other than SB?
It is.
And was
Somebody other than SB that he was getting too cozy with from the Explorer program and had to be warned off, and apparently didn't heed that warning. Nice. Oh, this is great for us to be hearing. Almost like, it's some sort of hunting ground for these predatorial cops. That's wonderful. Good job on you, Mr. Devine, for airing all of this publicly. I'm glad that we get to know that.
that person an adult at the time?
Yes.
Do you have an approximate time frame for that? And what about Mr. Devine serving as a witness for the indicted officer? When was that?
So he was a witness in, I want to say, in 2004. The sergeant ended up getting a second trial, and I think he got a second trial in maybe 2009, somewhere around there. At the time, there was a new chief coming in, so that probably had a factor in on his decision to not be a defense witness. I think that was the time frame. I could be off.
So he was going to cross the thin blue line and provide testimony against an officer who's accused and apparently convicted of crimes, and then he backed out of it. I'm curious what that means. Of course, you don't have a choice whether you testify or not. The defense has subpoena power, just like the prosecution does. You can compel witnesses to be brought into court to testify. But as a practical matter, if they're not going to be helpful to you, or if they're going to be unfriendly, perhaps, it's a little bit risky to do that if they are indicating that they don't want to be helpful. So I'd love to know some more context about this. I don't know if we're going to, but you know, the freedom that you have to deviate from previous statements maybe that you gave to the defense or anything like that is going to depend a lot on you know, how well they're documented. If you don't mind lying and changing your story, and you just talk to the guy over the phone, and there's never been like a sit down deposition or anything like that, then it's going to be a lot harder for that lawyer to pin you down, because, you know, unless they had a third party witness, an investigator or somebody like that listening in on the interview, they don't have any way to prove what you say that you told them. So that would tend to be my suspicion for something like this, because if you have him on record with the testimony that you need, then you can typically call him anyway, and maybe he's not cooperative, but then you can bring him back by impeaching him with his prior testimony if he needs to do that, if you have it in something like a deposition or a recorded statement. So we've already heard, you know, indications that some of the concerns about Mr. Devine have to do with dishonesty. They're not telling us explicitly that that's what's involved here, but there's kind of an implication to me that that's likely what's sort of lurking in the background here, because otherwise the defense would call him whether he wanted to or not.
Objection, motion to strike. He's offering my client state of mind.
I don't think I understood the question answer to be that.
Okay.
So, but I am going to ask you, Chief, to keep your voice up.
Oh, I apologize. No problem.
Were there any other conflicts that you remember?
No, not really. No.
After you became deputy chief, was there any point at which the relationship was mended?
To the degree that he was a subordinate, his father had passed away. You know, I just felt like he was really down in the dumps, and I had extended an olive branch, had a quick conversation with him about loss. You know, I struggled with the loss of my father, and I know that he probably was feeling the same thing. So I felt it was an opportunity to extend an olive branch.
From your perspective, did he accept it?
He did.
Okay, you're gonna have to pause for me here because I've got a little cat management I need to do. We've got cats over here taking over the desk where they are not supposed to be. Go sleep with that dog. I've got another one over here who's not being too bad, but that's really just a matter of time. So anyway, you're blocking my screen, sweetheart. All right, let's continue.
And approximately what year did that occur?
I don't know, 2017 or 18. I'm not really sure.
Your knowledge was that Mr. Devine demoted in 2015.
Yeah, it was either 15 or 16. Yes.
And what was his rank at the time he was demoted?
He was deputy chief of police, but he had civil service rank as a lieutenant.
And what was he demoted to?
Patrol officer.
Was there an internal affairs investigation to your knowledge that took place?
Yes.
Were you any part of that internal affairs investigation?
No.
Do you know what rank you were in 2015, 2016?
Yes, I was sergeant.
So at that time, Mr. Devine still outranked you.
Yes.
And typically, is it the policy that you're not involved in internal affairs investigations for people who outrank you?
I mean, typically, unless you're a witness to the event.
Now, despite your personal relationship, do you believe that you held out any biases against Mr. Devine in the workplace?
I do. Objection. Oh, sorry.
Oh, he objected too fast. He objected, but the guy says, yeah, he does think he was biased. Oops, never mind. Never mind that. Oh, that's funny. If he had been a little quicker on the ball, like you're supposed to be, and objected when the question came out before the answer, he wouldn't have gotten that answer and he wouldn't know, and he might never get that answer. But that's a pretty important admission there, isn't it? Yeah, he thinks he was biased. Ew, where's this going to go?
So I was wrong.
And do you want to roll on the objection?
No, it's withdrawal. Those are the easy ones to roll.
And what was that bias?
I didn't have any bias against him. Maybe I misunderstood your question. I don't think I had any bias against him. So I apologize if I misunderstood the question.
Psyched him out there. Got him to withdraw his objection and then explain I misunderstood. In fact, I wasn't biased. That's a clever one. That's a clever one. I don't think he did that on purpose, but that's a pretty good trick. Give them the answer they want, withdraw the objection, and then, oh, actually, never mind. That's not what I meant. Now the testimony's going to stand. Maybe he'll renew his objection.
So, okay. So just to be clear, do you believe that you held any bias toward him in the workplace?
No.
And that's despite any personal differences, correct?
Yes.
Now, in February of 2021, did you come to learn that the individual SB was found dead in her apartment?
Yes.
Do you know the date of that?
This is early February, I believe.
And that's 2021?
Yes.
How did you find out that information?
Chief McNamara and I ended up on a three-way phone call with Lieutenant Fanning from the Mass State Police. Some information had made it back to the department through Detective Shanna Isabel. She had, some sort of a relationship with SP, and she was trying to help her. So I believe she was aware of it, but the chief and I got the official notification from Lieutenant Fanning by way of a three-way phone call.
Did you know SP personally?
No, I knew her from around town.
What are the circumstances where you would have seen her around town?
She worked at the Dunkin' Donuts that I stopped at. She'd go to public events. She would always go out of her way to greet and be polite to officers and public safety in uniform.
After her death, did there come a time when there were allegations of an officer's misconduct within the Stoughton Police Department related to SB?
Yes.
And how did that come about?
There was another phone call from Lieutenant Fanning, giving the chief and I an update on the circumstances and explaining he was doing a criminal investigation.
But which officer was that?
Lieutenant John Fanning.
Which officer had the allegations of misconduct?
At that time, Lieutenant Fanning made us aware from the information that he had that there was a relationship between SB and Matt Farwell.
How early on in the investigation did you learn about the potential relationship between SB and Matthew Farwell?
Within weeks.
Within weeks.
What did Stoughton Police Department do as a result?
So the chief and I had some meetings with the town manager, town council. We opened up a case file. The chief directed I begin in internal affairs alongside the work of the Mass State Police. Went into IMC, which is our computer database, and we locked out everybody to access to records to SB. And the only ones that had access to the records was myself and the chief. Printed off a hard copy of everything that we had in the database for her, and then it was just sort of a holding pattern until we heard back from the Mass State Police.
How soon after you found out about the alleged misconduct did you let Matthew Farwell know about the allegations?
I think it was when we found information that implicated him We put him on paid administrative leave after an extensive discussion with the town manager and town council.
Got that police misconduct with a former explorer and you get a paid vacation, paid administrative leave. This civil service situation, I mean, what a gig. What a gig, right? Farwell gets a paid vacation. Devine gets retirement with pension. And people wonder why cops act like this when there are apparently no consequences, no serious consequences. All right, Farwell's experienced some consequences, but Devine, what? Some embarrassment? I mean, but for him digging the hole deeper, that would be pretty limited. But he's insisted on this hearing. Paid administrative leave for Matt Farwell. And they knew within weeks. What exactly did they know? That's what I want to know. What did you know within weeks? Okay, a relationship with her as an adult, but when did you learn about his relationship with her as a minor? Because that's quite criminal. Quite criminal. And that's the corruption here that implicates the MSP, Lieutenant Fanning, their investigation. That's what I want to know. When did you find out that this misconduct dated back to when she was a minor? We're probably not going to hear it in this hearing because it won't have anything to do with Devine, but yeah. $1 million question.
Were you assigned to the internal affairs investigation?
Yes.
Was anyone else from the Stoughton Police Department involved in the investigation?
No.
What was Chief McNamara's role?
So in the organizational structure and policy, the chief is the decision maker for the investigative work that I do. I would make recommendations to the chief on any IA. The chief would receive sometimes daily, but by policy every 7 days, an update of in some form or another about what was going on with the case.
Did you maintain that system throughout the internal affairs investigation?
Yes.
And is it fair to say that it lasted well over a year?
Yes.
Was the related Massachusetts State Police investigation around SB's death part of the reason for the delay?
Yes.
Were there any other reasons for the investigation taking so long?
I mean, I knew that according to the information I was receiving from Lieutenant Fanning, they were having difficulty breaking into the cell phone. The data that we had was only from a laptop sync.
Do you know where that laptop was recovered?
I believe it was recovered in her apartment and held by the Mass State Police.
Did you ever take custody of that laptop?
I did.
And did you ever receive the data download from that laptop?
I did a partial one, yes.
From who did you receive that download?
Lieutenant Fanning.
Were her cell phones ever cracked?
Yes.
And what does it mean to crack a cell phone?
Apple iPhone is high with security, and they use an algorithm program called Gray Key to break through to get the pin broken so that they could actually access the phone and download everything into Cellebrite.
You remember those, of course. We remember those, of course. Gray Key plus Cellebrite. Perhaps they used Axiom Magnet. Perhaps they used, what was that? What was Ian Whiffin's personal company, his own software that he was trying to market? No, I doubt they used that. Yep. Had a Gray Key to get into her phone.
Did the state police ever provide you with data from her cell phone?
Yes.
Was the data from her cell phone and laptop incorporated into the internal affairs investigation?
Yes.
When we're discussing volume of evidence, how much are we talking for this investigation?
Tens of thousands of pages.
What do those pages consist of?
calendar information, text messaging, contacts, emails, photographs, videos, just everything that you would have in your cell phone, only in Cellebrite, well, data format.
And not just in your cell phone, but everything that has been backed up to your computer as well. It sounds like, because sometimes you use your Facebook Messenger app on your phone, and sometimes you use the Facebook on your laptop, and all of that is going to be synced up. And so it's like it's even more than just what you have on your phone. I mean, I don't know. I don't get the impression she was a wealthy woman, so I don't know that she had a whole lot of different devices. But typically your phone and your laptop, particularly if they're linked up with your cloud account, that is going to be pretty comprehensive digital footprint. Like, that's her digital life that they got. Yeah, that's going to be a lot of data.
For how long was the investigation solely focused on Matthew Farwell?
In the beginning, it was, and then we learned of contact with other members of the department or former members of the department as well. I'd say that was probably about late spring, early summer that it materialized into other people.
And is that still in 2021?
Yes.
Who are the other officers that ended up being involved in the misconduct allegations?
It was Billy Farwell, Matt's twin brother, Josh Heel, the former animal control officer that later became an Abington officer. There's a couple officers that we had as witnesses, but not that were implicated. And a member of the military that was implicated, that was referred back to them. And I think that's it.
So was Mr. Devine ever the subject of the IA?
Yes.
When Mr. Devine became a subject of the internal affairs investigation, did you consider recusing yourself?
Effectively, I did, to the degree that I did not interview him, but I had to have a role in what was happening with the case.
Who interviewed him?
Retired Captain Paul Littleine, and I believe he had with him retired Lieutenant Bob Fries.
Were these other investigators independent of the Stoughton Police Department?
Yes.
How many investigators did you have other than yourself?
3.
And were they all former state police?
Yes.
Now, you stated that you did not participate in the interview of Devine, is that correct?
Yes.
And why not?
I mean, I figured that, if there was something that resulted in him being implicated in any way, that he was going to claim some sort of bias or personal grudge on my part.
During the investigation, did you personally interview either William Farwell or Matthew Farwell?
No.
At the conclusion of your investigation, were either of the Farwell brothers or Mr. Devine still employed at the Stoughton Police Department?
No.
And what happened?
So Rob Devine ended up retiring when a second interview was being scheduled. Billy Farwell had been on military orders, and he was already aware that he was going to be a witness, but he was, in my opinion, he was delaying or dodging having to sit for an interview. And Matthew Farwell, under the advice of his attorney, ended up resigning.
So I find it interesting, too, that he retired when they were scheduling a second interview, because what that implies to me is that they needed to follow up on his first interview, which means there are things that they needed him to clarify or perhaps see if he needed to correct. Perhaps there were some contradictions or inconsistencies that he needed to be asked to explain. And rather than do that, in a situation where he's going to be under oath, we heard that yesterday, I believe, from Chief McNamara, that law enforcement witnesses would be put under oath, but civilian witnesses would not. So if he's going to be confronted with, lies under oath and has to come up with more lies under oath, that's a pretty dangerous situation to be in. So just kind of adding to the suspicion of dishonesty that seems to be surrounding this cop, and why he would want to avoid that second interview, because it's going to confront him with stuff that he doesn't have an answer for without digging himself a deeper hole that could potentially get him into some murkier waters.
And did Mr. Devine retire?
He did.
How close to the end of the investigation did you retire?
I mean, it's a 19-month investigation that began in February of 21. So, excuse me, I think it was sometime in 2022.
Was a large part of the investigation the review of digital evidence?
Yes.
And why is it?
It was really all we had to go on, other than witness testimony and anything that would have been reported or called in by any of SB's friends. The data was the heart of the case.
And part of the data, as you stated earlier, was her SB's personal correspondence.
Yes.
Was there correspondence between SB and Matthew Farwell on the devices?
Yes.
And between SB and William Farwell?
Yes.
Was there any correspondence with an individual with saved as the contact name Robert Devine?
Objection. I'm sorry. I was on my objection.
Oh, okay.
So, did you ask me screen name?
When their contact name shows up in correspondence, was anybody reflected as Robert Devine?
No.
Did you later believe that some of her correspondence was with Robert Devine?
Yes.
And in what form was that correspondence?
Facebook ID, Marty Riggs.
Are you familiar with the name Marty Riggs?
Yes.
And where does it come from?
Lethal Weapon.
Is that a movie?
It is.
I don't remember who Marty Riggs is. I probably should remember who Marty Riggs is, but I don't. So I might have to go. I might have to go do a little research after this. I forgot. This came up during the first part of the hearing as well. This Marty Riggs pseudonym that's being used, and so we heard that they think that that's Robert Devine, but we haven't heard yet why they think it's Robert Devine. So that's going to be an important part of tying these pieces together here.
Ask that the witness be shown in Exhibit 1. One moment. Can we go to page 38? And do you recognize this information, Chief? It's in the notebook to your left as well.
Yes.
And what is this a discussion of?
This is an excerpt from my investigative report. Describing I met with.
It should be in front of you in the binder if it's easier to read.
This one?
Yeah, page 3.
I mean, yes, it's going to be redacted, and we're not going to get to hear, since obviously we don't get to
38
see.
is an interview.
Yep.
I don't know if this is a different page sequence.
Oh, so it should be on the post-Devine closed hearing. So it's in the center of the page is the page number.
Sorry.
So that's 40. 38. Yeah, sorry, where did you want me to begin?
The midway through that first paragraph, based on. So are these the reasons why you concluded that Robert Devine is using the alias Marty Riggs?
Well, that and a Cellebrite screenshot that had.
So we don't
Can
get
I
to
ask
hear
that
this
the
either?
witness be shown Exhibit 8, 897?
We don't get to hear why they think he's Marty Riggs. We just get a Cellebrite screenshot. That's kind of lame. I mean, I guess it's because of this protective order stuff. but it's like you're using it now in this proceeding. Oh, it's probably the FBI restrictions. You know, we saw that with Karen Reed, that when the FBI provides their information, it's they often will do so with some conditions attached to it. You can use it, but this, that, and the other. It's just that normally by the time you're using it in some kind of public proceeding, you're using it. Like now we have a right to know, because we have a right to know what these proceedings are based on, what they're relying on. This is a basic First Amendment common law kind of thing. But maybe just the nature of this proceeding, I guess, the post proceeding, they don't think we have a right to it. I don't know, but I think it's kind of important to know why they think he's Marty Riggs, if that's like the prime reason why they think he's committed this misconduct in 2021, since that's part of the basis for the decertification. That's, you know, big chunk of the reason why we're here in the first place. Devine is in many ways doing what we call a collateral attack on the 2021 IA investigation. He went ahead and noped out of the department rather than participate in it. So because of that, no, he didn't have to sit for that second interview, but he also didn't get, you know, the quote unquote chance to defend himself. So now he's taking this opportunity then to challenge the 2021 IA report on the grounds that you know, it wouldn't support a decertification if he just had the one incident back from 2015. So, you know, him being Marty Riggs, really important. Kind of feel like we should get to know that. Not real pleased that we don't get to know any of the details of that, other than there was some sort of Cellebrite screenshot. Cellebrite from what? From his phone? From her phone? It's irritating.
Right, I object to this exhibit. I don't believe it was a download from a Cellebrite. Also, we can see this highlight on this document.
So let me get clear. First of all, this is from which exhibit? It's part of.
So, and I was able to recreate the same screenshot yesterday.
What do you mean recreated?
I found the data within the raw cell phone file.
But it was also in exhibit 2.
Correct. Yes.
And the way it was received by you, did it have the circles and the lines?
From the Stoughton Police Department, yes, but I created a clean copy yesterday if the court would like one.
Oh, without that?
Yes.
I'd like
That satisfy you?
yeah, we could get a copy of it.
I can forward it to everybody right now.
Okay.
Or should I wait?
Well, I think we've got to be looking at what we're considering. So
Okay.
why don't you?
Guess we're
I'd like
going
to
to
add further,
pause.
Your Honor, that what has been represented to us and what has been presented to this court is not this particular document, but is located on page number 625. As part of the Cellebrite. It is actually part of the Cellebrite exhibit.
So there's another form.
It's a very different form, very different document.
Well, right now, let me see what the division sends to us. I know what I'm comparing it to.
I mean, this is all
Did you get the email?
kind of meaningless to us if we don't get to see the docs
And we are
anyway,
going to print
or
out
even know what they
hard
say.
copies if anyone would like one.
Yes, I would like one.
Great. Penny, do you want to print out 5 copies? Yes. And for the record, with this exhibit that Attorney Martinez just sent, should we make a separate exhibit and add that to?
I want these to be, just so there's no confusion later on, separately mark the document that Mr. Martinez just sent us as a separate exhibit, and then mark the page from that was initially displayed from the exhibit 2 as a separate exhibit. And perhaps the Cellebrite one, but let me see what I'm looking at first. Mr. Martinez, are you aware that Cellebrite extract, there's another copy of it in there as well?
So in Exhibit 2, which is the data extracted from, essentially there's a Cellebrite program where you can open up all the data in her phone. So on the left, you can see that's where I was able to access all the contents of her phone. And in the top right, you can see, on the left photo, in the top right, you can see all I did was search for Devine. It's in the left photo, toward that right corner.
Your Honor, I object to counsel becoming a witness in creating and producing documents during the course of the hearing.
This is sort of a fair objection, but it's also sort of not, because if the data extraction itself is one of the exhibits that's before the commission here, then all he's doing is providing instructions on how to identify where in the exhibit this particular thing that he is offering, this particular part of that exhibit, can be found. I'm not sure that's a great objection, but we'll see what this guy thinks.
I'm not, and right now I'm trying to figure out what the source of the document that's being shown to me is. That's all. I'm not making judgments about its authenticity, its truth, or anything else. I just want to know where I'm getting this stuff from. So this, what we've just received and was just described by Mr. Martinez, I want to mark as a separate exhibit. Right?
Yes.
Which will be, what numbers are we up to?
I believe it would be Exhibit 9 for the division. And correct me if I'm wrong.
That's correct.
And the page that was extracted from Exhibit 2, the one that was up before with the lines on it, we made that a separate Exhibit 2?
Yes, and that was page 897.
Yeah.
So if the parties agree, that could be the division's exhibit.
I think that's already 8.
Oh, okay, perfect. Judge Fishman, though, did you want to make that part a separate exhibit? All right.
So Exhibit 8 it's a lot of data. It's not a single document, is it?
Exhibit 8 is just that screenshot with the yellow highlight and the lines.
Oh, okay.
Yeah, it's just that single page.
Thank you.
If I may, Your Honor, the exhibit on page 625 is actually what was produced. It is very different from what we're looking up here and as presented on page 897.
Let's bring that up to 625, which was from.
That sounds like something to
Exhibit 1?
cross-examine on.
Yes.
Good Lord, can we just get done with this?
I believe 625 is Exhibit 2. But again, the Exhibit 2 is all extractions from the hard drive.
Right.
So this is the extraction.
So since we submitted exhibits, since we did motions in limine, I've had Exhibit 8 and it's been the same document the entire time. I also included this within Exhibit 2 when the court asked for me to include excerpts, but Exhibit 8 had already been included as part of the exhibits and was already one of the proposed exhibits at the time of the motions in limine.
So is your position that Exhibit 9 and the Exhibit 2, page 625 are the same document?
No, Exhibit 8 and Exhibit 9 are the same.
But we have something else now that's being shown to us exhibits.
This is, I believe this is the screen that the respondent mistakenly believed to be the same as Exhibit 8, but it's not the same.
Exactly. That's the point. This is what was produced.
Well, you've had the entirety of Exhibit 2, right? So you would have had page 897 from Exhibit 2 that was produced to you as well, right?
Yes.
And that's the one with the lines on it.
Yes.
And is it your position that page 897 and page 625 are the same document without the lines?
897 and 620. No, I'm suggesting they're very different documents.
He's trying to say that he didn't get what they're trying to offer, right? That all that the defense was provided in discovery was this page 625, whatever it is. And it's a different document from what's in this Exhibit 8. But Exhibit 8 is derived from Exhibit 2, as is Exhibit 9, derived from Exhibit 2. And the judge has pointed out, you had the entire Exhibit 2. So you had the ability to get this Exhibit 8 and Exhibit 9. They were all in it. Plus Exhibit 8 itself, the commission's lawyer, the division guy, he says he, submitted that as part of their pretrial exchange of the exhibits. So he can't come out and say, they didn't give me this, I don't have it. But he's trying to say, I've never seen this before, and somehow also make that the other guy's fault. Okay, you had Exhibit 2, which seems to be the extraction or some type of report of the extraction, but he didn't look at it. So now he's claiming surprise, but it sounds like that's a your problem type of situation, not anything that's the fault of the proponent here.
And if you look, Your Honor,
I'm trying to figure it out.
But
the other document doesn't. She owns this account.
Please. When you say this, we're talking about a lot of documents. Right now, we're looking at Exhibit 2, page 625, right? Correct. All right.
so
And I see owner participant. Yeah.
I do just want to be clear. The division isn't representing that this is the same as 897.
No, I understand that.
Yeah.
And I can't compare the two without. I'm going to look at the one so I can compare it.
Oh, good Lord.
Apologies, I'm trying to print the exhibit.
Yes. Just so I've got this clear. Exhibit H, which you separately took out of the math and isolated. Are you saying that was found originally as part of the Exhibit 2?
Correct.
In okay. And when you saw it in Exhibit 2, it contained the yellow circle and all.
No, it did not.
No. But you also say it's different than this that appears in Exhibit 2 as well.
Yes, so this is different than the document that I was showing and that I was able to recreate yesterday.
And the document that shows the lines was from Exhibit 1 originally, 38 or something like that.
No, it's directly from the Stoughton Police Department. It's not included from so it's within the data in Exhibit 2. So
That's what I'm asking.
Yes, so it's included in the data in Exhibit 2. Yes.
And when you said found in page 38, is that where it was in Exhibit 2? Wouldn't page 38 of all these documents wouldn't be at page 38?
No.
I got you.
Exhibit management, guys. Critical skill.
Yeah, why don't you do that? That would be helpful.
This is why every lawyer really
Right now,
needs
I
a
just want-
sleuthy goosey
You get 3
or an
seconds?
Olivia Lambo.
Yeah. Might be a little
Amazing.
hard to see, but I put one up here too.
All right, so let's make sure.
They could just be sitting right there next to that lawyer.
So what I want to do first of all, with regard to the
Correct,
first
exactly.
one I sought to introduce, which is now on the right-hand screen, one on the left, right? It's in the right-hand side to the document on the left on the right-hand screen, right? Just so we're all literally on the same page, which was found that I want you to lay a foundation for that document comes from, and then we'll figure out the other two in a minute.
Yes, so I received that from,
Can you do it with him?
no, I received it from, the Stoughton Police Department, from Chief McNamara.
So it's, now hold on. The one with the markings you received,
Yes,
when?
um,
So it's not contained in the exhibit.
yes, it is. Yes,
Is it part of exhibit 2?
yes, that's where that information is
Said
derived from,
this.
exhibit 2.
Like 10 times.
So the entire cell phone contents are on exhibit 2. That's where this came from, is the cell phone contents.
But without the markings.
Correct, without the marking.
That's what I'm talking
Oh,
about.
okay,
So
yes.
the mark document came separate.
Yes, it did.
And so it hasn't.
Yes, it has. I offered it even before the motions eliminate, and it was admitted into evidence
As identified as what?
as an extraction from exhibit 2.
And that was exhibit 8.
Yes, correct.
It was identified.
Hold on. Let me follow my train of thought here.
Here is what it seems like happened. I don't even want to pause this because I want them to just get this done.
Well, I'm troubled by this, the foundation. It's one
The
thing that
original-
I've been-
Screenshot was in the extraction unmarked. The Stoughton police chief or somebody in Stoughton printed it out and
Now,
put some
it's
highlight
a
markings
different
on it.
criteria for a disability.
and
in
gave
terms
them that
of
separately.
authentication without knowing how
He
the markings are
originally
created. I
used-
mean, I understand that's why you cut it.
He originally used the highlighted one, but now he's gone back and just gotten the original without the markings on it out of the exhibit 2. So this just, it does not seem this difficult to sort out, but now we've got all these grave concerns about the foundation. Ugh. All right, tell us what your grave concerns are.
Create a clean document, or clean that up.
Right.
But do you believe this witness can explain the document markings on?
I don't believe so, no.
You know, any reason.
Yeah.
But the last witness should have been able to do that, I would assume.
Possibly, Your Honor.
Well, and what's presently 8 is the clean copy that one would find if you went into the,
Exhibit 9.
excuse me, exhibit 9 is the clean copy, but you
Correct.
would find that if you plowed through all of
Correct.
those documents,
Yeah.
right?
Correct. Yes, we can take exhibit 8 out and put in exhibit 9, but I neglected to ask Chief McNamara because as we saw, she wasn't as involved in the IU report as.
Well, I'm not sure what we do yet about 9, but let's talk about 8.
Yes,
I don't believe there's adequate foundation for 8, and I'm going to, and you're seeking to exclude it, are you not?
I am.
All right, so exhibit 8 is an objection to exhibit 8 is sustained. That'll be, I want to separately mark that for identification so it's there for future purposes.
That's the marked up
We
one.
were actually having our first exhibit for identifications. Let's just call it A for identification. Everybody's all right with that. And let's turn to exhibit 9 for a moment. And I do want to hear to the extent that I'd like to use foundation questions in regard to that
okay, as to the cell phone data?
from where this document, you say it's extracted.
Chief Holmes, during your internal affairs investigation, did you review some of the raw data from SP cell phone?
I did.
Can you look at the screen now as what's displayed? Does this look familiar to you?
Yes.
And what is it? What are we looking at?
The left is,
Objection.
excuse me.
If I may, Your Honor, in the middle of the trial, a document is being presented as evidence. There are, to the left of it, as part of this document, there are several names on it. We don't know what any of this is, and we shouldn't be blindsided in the middle of a trial.
I am blindsided. No one's blindsided you. That's why I'm trying to determine whether it should come in. And I'm certainly going to hear your full objection to it once I hear what the foundation is. So continue, please.
So what's displayed on screen?
So the left side is Excel. The format is more or less Excel when you're in Cellebrite. So when you pull up a data set, you get the spreadsheet that you see to the left, and when you highlight it or click on it, you get the cell to the right that provides data on what's being highlighted. So when you see the blue left side highlighted and you click on it, which I did, you get the screen on the right, which will give you indicators of what it is.
And that's the information contained within that particular message or contact or whatever it may be.
Correct.
And this was material that you received as part of your investigation. It was contained in the exhibit to your investigative report.
Yes.
But when it was contained in there, if somebody were just simply to open that material, would you see the document on the right? Would you display the document on the left, or do you have to do another exercise and process in order to do the to be able to find that list and click on Riggs and find that document?
So if I was to go up a cell, Your Honor, and click on whatever that name is there, clicked on that and highlighted it, you get another screen to the right. But before you start clicking on any of the cells, you don't have anything on the right. That pops up when you're in the cell that you want to look at and examine.
So you're saying without doing that exercise, you wouldn't be left look at the downloaded information and find this very same document on the right? If you did without doing that document on the right, is that what you're saying?
Yes. So the left is the result of whatever search criteria you put in. Might have been contacts, might have been names, it might have been whatever filter I was using at the time. And then it's not until you click on that cell that you get a document or an information field on the right.
So when this document was produced to the respondent, they wouldn't have seen any of this.
All of the information is contained within Exhibit 2. The respondent has had the raw cell phone data for 15 months.
So you're saying that the respondent would have been able to do the same exercise that you did in order, or whoever did this, in order to bring up that document?
Yes.
No, it's Cellebrite. Wait, please. I promise you, you'll get your chance.
And I would be able to recreate it right now as well. With 3 clicks. Once you upload the raw cell phone data.
Let me hear from you.
Well, Cellebrite is on $10,000 a month. Cellebrite program. I looked it up. It's cost prohibitive, clearly, for an independent person to do. But
10,000 a month, 10,000 a month. That's quite a grift, isn't it? 10,000 a month. Now think about how many police departments, sheriff's departments, federal agencies, administrative agencies, all of these investigative bodies are paying Cellebrite licensing. Intriguing. So he's saying, well, I didn't look at it because I wasn't going to pay $10,000 a month for Cellebrite. That's not a terrible justification. I mean, there is an argument potentially to be made that discovery needs to be provided in a format that allows you to know what it is, be able to read it, be able to navigate through it, be able to search it, particularly if it's a database type of document like this. However, I'd want to know, did you go to any effort whatsoever to, for example, inspect it at the police department where they already have the Cellebrite? That's what we used to do. We do that routinely in certain cases involving certain images of certain, younger individuals, because you do not get nor want a copy of that on your own computer. You don't. It's not something that is really on anybody's short list hopefully good lawyers anyway. So you go and you look at that on the police department's computer or on the prosecuting attorney's computer. And often, like, they're so used to that, they'll have a special workstation where, you're in a private room and, so nobody's watching over your shoulder at what you look at and stuff like that. And you can do exactly what they do. You can sit and look through the entire extraction. Now that's just within Cellebrite. What he seems to be referring to is the report that Cellebrite produces when you get a full system extraction, and it does that through like a complicated Excel type of program. So you don't need Cellebrite to be able to navigate the report. You can run that through just a normal normal office type of program. So 10,000 a month, though. Intriguing.
We were unaware.
But you received this.
We were unaware that we could access any of this. We received the reports as they were reports in PDF format. We've never seen this. We've never been availed the opportunity to do this. And also, Your Honor, if I may just point out, we have the headings, and then we have a slide over. What's over? What's over here on the other? That's off screen.
You sure you want to know?
I think it's going to say the owner is SD. Like 625, page 625 says.
There's no doubt that the owner of the cell phone is SD.
I know. We'll be able to argue what that means.
Yeah.
Right now, later on, people can argue with the relevancy and probative value of this. Right now, I'm trying to figure out what comes in. I want to make sure two things. One, that it's something that was contained in the exhibit that has been admitted to evidence. I don't want it, if it's extraneous, then it's a whole different inquiry. But what about the notion that what the respondent received was a PDF file and not the ability to open it up and do exactly the exercise you did?
So that's factually untrue, because you can open up the hard drive that I gave to the respondent, and there's a program, Cellebrite, that you can open up and then open up the raw cell phone data. It's downloaded onto the hard drive.
It's on the drive.
Yes.
I was with Attorney Martinez about 2 weeks ago with Mr. Devine, and I tried to do that with the drive I had in his office, in the conference room, and it wouldn't work. I tried to do it with him, and it wouldn't work.
Why were you trying? Because you had learned from him you could do it, or because you expected to be able to do that?
No, because your Honor had told us to meet and go through the exhibits.
I realized.
And we were going through the exhibits, and I'm like, we can't get into this, and we can't. And he said, I can't get into it either. In the presence of Mr. Devine. That's why I brought Mr. Devine with me.
The plot thickens.
That's untrue, first of all. And second, he had this information for 14 and a half months, and 2 weeks before the hearing, he said, I've never seen this file on here before. That's not my fault that Mr. Devine,
But 14 months ago, he had tried to do it just as you tried to do it in your office. Why should I believe it would have produced what you have here?
So what Attorney Stowe said when...
Remember, you're talking to a digital neophyte, so don't get too...
What Attorney Stowe had said when he attempted to open that file, and actually had also said so several months ago, was that, oh, I think I need a new laptop for this case.
I'm Brian Holmes right now. This is me right now. I mean, it seems like this is a pretty critical piece of evidence for the basis of the 2021 discipline, concluding that Robert Devine was Marty Riggs. And so I'm really sympathetic to this. Apparently his name is Martinez, this attorney for the division. I am really sympathetic to his plight in trying to explain this to the boomer judge who doesn't know how to navigate a spreadsheet, let alone how stuff like this is provided in discovery. So yeah, that's something that happens sometimes. You'll get like a proprietary format for like a surveillance video or something like that, and they will provide the file, but then they'll also provide a copy of the application itself. So you can download the application to your computer, and then you'll be able to watch the video that they're providing in Discovery. And that way you get it in the original raw format and not some modified version that's being run through like a Microsoft Player or something like that. So that's what they did. Give him a Cellebrite reader type of program. And he's saying, well, we tried to do that in his office 2 weeks ago and it didn't work. And Martinez is saying, well, you said it was the problem of your computer and you've had it all this time anyway. It's not my fault if you waited until 2 weeks ago to go in and look at it. And I tend to sympathize with that because yes, that is not his fault. It was provided. It was provided.
Because my laptop does not work to open this file.
And you agree that when you're in your office, he was unable to do that?
On his MacBook 2 weeks ago, correct?
Oh, well, I know
Yeah.
the recency of it.
But, sorry, excuse me, he made one attempt to open the file. And at that point, he said, I think I may need a different laptop.
Could I clarify for Cellebrite? Okay.
If somebody wants to question you about it, Chief, you'll be able to.
Yes, sir.
Do you say you can do that right now?
Yes, I can.
Go ahead and do that. So
Why don't we just do that? Why don't we just go ahead and open up Exhibit 2, use the Cellebrite reader, get us right to this document, and show him it's there.
You can turn your Martinez should plug the hard drive into the computer so everyone can see.
I don't see an issue with that.
Yeah, nobody turn off the Zoom share. Don't share the screen. No, share screen's off.
Would you like me to come up there? Or
how you want to do?
would you like me to bring my laptop up? It may be easiest to do it that way.
Yeah, sure. Why don't you do that? We have an HDMI cable, so just
Like the one
Connect,
using here?
oh, there's another one right
The
there.
judge doesn't know what any of that means. He doesn't know what a HDMI cable is.
Okay.
It's completely dependent on the staff to take care of these issues for him.
May I approach?
Yes.
And Attorney Stowe should likely come as well.
Yeah, I think that's perfect.
Attorney Martinez, you can actually go with Penny. She has. Yeah, I'll show you how to control it. Alright. Can you plug the hard drive in?
I think, okay, that actually might be better than my laptop. You have to go to, sorry, where's it at?
I can show you.
So this is Stoughton, all this information is what I turned over to the respondent. If you open these files here, here's the Cellebrite reader.
What are you calling it? Cellebrite reader?
Yes.
Cellebrite reader.
And it will likely take a few minutes because the amount of data that it has to load.
Twiddle our thumbs to load the extraction. No wonder this hearing took so many hours. Where are we at even? We're not quite halfway through. Hopefully they'll get Cellebrite loaded before the end of this hearing.
So then this comes up and all you have to do is click activate later because there's already a user information. And then the cell phone data automatically pops up. Oh, it looks like this isn't being.
Yeah, if you drag it over.
And it will take a minute. You can see it loading on the bottom right there.
Yes, Holmes. Me too. Me too. I also am gonna do the glance to heaven and face palm.
While we're waiting, Mr. Martinez, you say that what you produced, the drive you produced, had the ability to open something about welcoming to Cellebrite read.
Yes, exactly. Yes, what I just logged into what I just put on this hard drive is an exact copy of everything that I gave to the respondent. I believe I even copied it from this hard drive. Once all the data loads, it will be easy to navigate through, but it takes a while to boot up. Okay. So this is the front page once you open Cellebrite, and it asks for the time zone. Basically, I set it so the time zone is Eastern.
By the way, can you bring the page over to the right so we can see the end of that last column there?
This information?
No, the other way.
Oh, I can scroll this way.
That's what I'm talking about. Thank you. Scrolling to the right.
I believe it's the exact same data, just in a different form, the exact same.
But, well, you said you would expect to see the owner identified as being. No,
I said that, Your Honor, because
and I actually thought Mr. Martinez was agreeing. Maybe not.
Oh, no.
I object to Attorney Martinez testifying.
But in terms of what was brought up by doing the search again, can we see the full document on that?
You're saying click here?
No, to the right, that one. You were able to expand on that.
Oh,
That
yeah.
showed. That's what.
Does this remind anybody of like sitting down with your parent and
It's really
trying to help them
It's like the file
figure out
trail.
why Candy Crush crashed? No, click over there.
We're looking for is the proposed exhibit 9, which includes the sort of the search mechanism from Cellebrite left and the document that came up when the search was conducted. Why don't you folks go ahead and have a seat? And I'm going to hear from Mr. Stowe on his objection to that document. Well, let's wait till he's back. Don't wait till he's down before you argue. You can stay there. I just didn't want you to argue until he got down there.
Yes, yeah.
So this is kind of a do or die objection, right? And honestly, this is the nature of a lot of administrative litigation is just trying to sort of game the evidence process. Very helpful if you have a tech ignorant judge here, doesn't necessarily understand what he's being presented with. Because if they can keep this out, then they can potentially undermine the conclusion that Robert Devine is Marty Riggs. And if they can undermine that conclusion, then it sounds like they don't have any communication directly with somebody named Robert Devine. So they have a much weaker case for any kind of misconduct towards Sandra Birchmore. So that would mean, potentially problems with the 2021 discipline. And if the 2021 discipline is gone, then once again, we're back to no basis for decertification. So important objection here. Sounds like they were able to kind of work the judge through. Here's the document, here's the program, here's how you open it, here's how you navigate through that. All of it was provided to the defense. So it's just going to come down to was that adequate disclosure? Did they need to do something to call out specifically this unhighlighted document from the extraction? The division lawyer, I can understand his frustration. He's saying, I provided this specifically as an exhibit in the motion in limine hearing. It just happened to be the highlighted one. But the judge has already excluded the highlighted one because there's no foundation for the highlights. Who did it, when they did it, why they did it. It's an alteration of the original that hasn't been explained. So that's what it's going to come down to, was providing the extraction plus the Cellebrite reader adequate notice that they would be relying on this particular document, this particular data from the extraction in this hearing, without presumably having navigated it, navigated him to it directly or held his hand through the process of setting up Cellebrite reader on his laptop and so forth.
So what do you say about admissibility this time?
Your Honor, I have the same arguments as I had. It's the first time we're seeing this is now during the trial. I expressed my inability to open portions of software to Attorney Martinez. He didn't offer this as an option. He didn't offer that as an option. Actually, they made a call. Maybe they need something.
You know, for what is
Opening this up for me at his office or anything else. So he had his computer. He could have opened it for me.
Did you ask him to open it? Was he supposed to read your mind? Was he supposed to thrust this Cellebrite extraction upon you? I don't think so. I think you got to have some responsibility to ask for what you want, or it's reasonable for people to infer that you don't care that much about it and you've decided maybe you don't need to see it. He's supposed to offer? I don't think that standard's going to fly.
That's how I said, this is what's here. He actually told us he couldn't open it. So now here we are. And he said, I can't open this up either. And I believe he even tried to open it. Couldn't open it. So now here we are, 2 weeks later, and he said, oh, now I can open it.
What do you say about that last point?
That is just not true. I understand it's 2-1. I mean, I shouldn't have let Mr. Devine sit in on the meeting between two attorneys. But
did you make any attempt to open it? Well,
I did not on my computer. No.
Did you make any attempt to assist Mr. Stowe in opening it on his computer?
No, because Mr. Stowe said, I have a Mac. I think it's not working because it's a Mac. I'll have to get a new computer before the hearing, is what he said.
Do you disagree with that?
I said it might be time for an upgrade. About a new computer. I didn't say I was going to get a new computer for the hearing. I didn't say anything like that.
I don't want to make.
He said.
I understand. It's not so much testimony, but there is a issue of production here, which is what I'm calling it, and it is technically included in the docket in the exhibit that I admitted, which is Exhibit 2. It's there. You see it open. My question is, did you and you're arguing, look, I never saw this before, and I wouldn't have known about it unless told about it. And my question is, did you ever make any effort to use the Cellebrite reader in all the months that you had this document ahead of time?
I tried before when I got the discount for everything. I couldn't open it. And I talked to him. I believe I went into his office before and couldn't open it. And when he said when we met.
Well, that's important. You're now talking about something that happened 2 weeks before. You're telling me that sometime earlier in this discovery process, you went through the same exercise with Mr. Martinez?
We met a couple of times. And I tried to open stuff and he said, I can't open it either. Something we just can't open. So we left it at that.
You disagree with that?
I do disagree with that, and I specifically remember a few months ago he also said I might need a different laptop because my Mac is not compatible.
And at neither of those visits did you open it for him on your computer?
No, I did not. He did not ask me to either, though. And it's
But you
not,
had, the conversation you were having obviously had something to do with the fact that the Cellebrite reader function is there, that you were attempting to open it because you knew that it produced a document when you open it, it helped find a Devine reference, a reference document.
during the first interaction, he stated again, I think I'm going to need a new laptop for this case, and that was several months ago. And because he believed that he could not open it.
I'm on a different thing. I heard you say that. What I'm
Yeah.
saying now is the discussion with the effort to open this because you had some discussion between you about the fact that there's this function, the Cellebrite reader function, which you may or may not have known about ahead of time in your experience. But that's what you were trying to do. You were trying to open the reader in order to make a search for a relevant document. Is that fair to say?
That's true.
So it's not as if you received a PDF that was essentially like a photograph, a digital photograph of something, as opposed to a functioning, the terminology sometimes escapes me. I know in my head what I'm saying, but a functioning process of Cellebrite reader, interactive process would allow you to do some kind of search.
Right.
Database. The term you
do
want is
that, yeah.
database.
You couldn't accomplish it. I understand that, but you knew that was something that presumably ought to be able to be done because he was telling you that.
Yeah, he was telling me, he told us that he couldn't open it either. That's what he said.
So why were you folks even doing this?
Well, because you instructed us to go through the evidence.
That's 2
So
weeks
we-
ago. I'm talking about this month or 2 months or a year ago, or whatever the first time.
Because he couldn't open it either. We've had this conversation a couple times. We got a flash drive, and then I think we got another drive. But I think I met with him 3 times to get these documents. I went in, and it was twice because I went in, second time I went in, I said, I can't get this open. He said, I can't open it either. And then we said, again,
He couldn't open it either. You mean at that moment, or just?
I know what he meant by either.
And is that something you're saying didn't happen?
I never said that I could not open those Cellebrite files.
How long ago did you first able to open up and find that document?
Before I turned it over to Mr. Stowe, I wouldn't have turned it over if I wasn't able to.
I mean, so you've been aware of this. I'm not yet sure of all but you've been aware of the ability to do this in the production and what the search would produce for a while you've had this material. But you're aware that specifically on this hard drive, you could access, you could do the search through Cellebrite Reader.
Yes, I was aware. What was that?
And had accomplished it.
Yes, I had accomplished it even before the first time that I turned it over to Mr. Stowe in March of 2024. And the post commission does not have Cellebrite software either. It's saved onto the hard drive.
Yeah.
I don't think there's a rule
And
that
the clean copy that you had just produced as an extraction, that was the 3 things. We had this, we had the marked document. What was the third one?
I don't think there's a rule that Cellebrite Reader has to be provided in Mac format. I really don't. I mean, I can understand, yeah, that would be an issue if you're trying to run a law office through Mac. There's a lot of incompatible software, but that's kind of your problem and your choice. You need to get a Windows computer, and then you can run the Windows-based software, even if it's just a, backup for specifically this purpose. I don't know if Cellebrite even makes a Mac reader. I assume they probably do. If they're charging $10,000 a month, they can certainly afford it. But this is like infantilizing this lawyer. I couldn't do this. He didn't offer to do any of it for me. Well, take responsibility for your own tech issues. And I think that's what the judge is getting at here. If you'd looked at this a little bit earlier down the road and taken some initiative to fix it, you wouldn't be here complaining, I've never seen this before, because you had it for 15 months. So you had 15 months to fix the problem, but you didn't. I don't know how you attribute that to being the commission's problem here.
Actually, from exhibit 2, I wrote down, I believe it was
Page
page,
625.
yes, yeah.
Is that another, that's the one you say is different than this?
Yes.
Right. But it's, and you acknowledge it's different. It's a different image.
That's right. That's what we were produced.
I mean, that image was produced as part of the package of exhibit 2.
Yeah, part of the package, so yes.
It wasn't the only thing produced.
And presumably, if you go to if you went to the Cellebrite reader, you would have been able to find that document as well somewhere in.
So the source file on this one, there's 3 raw data files on the hard drive. The source file there is different, I believe, than the source file and exhibit. So there are multiple different raw files.
It's so annoying when we can't see what the
It's right,
documents
as another
are.
layer.
I don't know where this other
We
one.
proposed this based upon multi-layer hearsay.
Defense
If this is
lawyer.
a Facebook product, we've got statements upon statements and a production of documents by Facebook. Facebook has an agent in Massachusetts. They're a corporation within Massachusetts. They have a location, the CT Corporation Service on 84 State Street. They could have subpoenaed in the records from Facebook.
That's an address that Post-Commission is very familiar with.
Yeah, because I've got it from they changed their name to Meta. It's Facebook Inc. on 12/21/21. Exact name of foreign corporation.
Right, no, and that goes along with your objection. It should have gone directly to Facebook for authentication purposes. That's what you're saying. I understand, but I've ruled on that one. And but I have said that as you dig deep into the layers of hearsay, if there's, for whatever the evidence comes out to be, if it's being offered for truth and it lacks reliability, then I have to consider that objection as it comes along. But what I'm doing, I'm satisfied that the document that's now marked as proposed exhibit number 9 is data that was included in the exhibit, both material that was both produced to the respondent in this case as part of the and that it is a function that is available as part of that data as produced. And it's consistent with my ruling in admitting exhibit 2 in the first place to admit that. So I'm doing it over the objection of the respondent.
Finally, that only took like, what, half an hour? Okay, so they're going to be able to use this. There's been a hint here that they were objecting to the cell phone extraction as hearsay because it's a Facebook message. I don't really know what that sort of argument is based on. I guess what the original is like on the Facebook server or something like that, and that what's contained on the extraction is a report from the phone. Like the statement itself, I'm trying to follow this. Like, I understand how badly they need and want to keep this out, and so they will engage in very creative lawyering to try to come up with arguments to justify keeping it out. But I got to say, I'm having a hard time following the train of logic for why a cell phone extraction that includes Facebook messages that were presumably made on that phone, or at least the network that the phone is connected to, the ultimate cloud server that was shared, data sharing device for both the cell phone and the laptop. I'm not quite seeing why we had to go and get that from Facebook individually for it not to be hearsay, unless, like, is this electronic transmissions between servers or statements? I don't think they are. They're just the mechanism of communication. It's like if I'm talking to you right now into a microphone, the sound wave into the microphone is not a separate communication from the microphone to the speaker, and then the speaker out to your ear. Those are not three separate communications. It's just one. But I guess it doesn't matter. It sounds like the judge didn't buy it anyway. It's just interesting to me to listen with an eye to how desperately they were trying to keep this out, because it must be pretty bad. It must be pretty good evidence, even though I guess we're not going to get to see it, that Devine was Marty Riggs. And if I'm reading through the lines, it sounds like it's maybe from a contact where she's got Marty Riggs in the contact as Robert Devine or something like that. He searched the cell phone extraction for Devine. We heard him say that. And then this thing comes up and it's a screenshot. So he's going to admit it, it sounds like.
If you want to offer exhibit 2, page 625 as well.
That's one of their exhibits. I believe that's
No, I know. Well, I mean, to me, it would be sensible to separately identify that particular page now, because you have made it a relevant comparison, figure, both in terms of your authentication, hearsay, objection, etc. And so that the record is clean, I think we ought to mark it as an exhibit right now, separate exhibit, even though just like this one, arguably it's contained in another exhibit, right? So let's do that. Let's make that exhibit 10.
And that's on exhibit 2, page 625. Penny, can you pull that up? Because we are looking at this is 625. Okay.
It's further in my.
I'm going to add one more thing, just so your record is clean. I want to make a copy of that and separately mark the document as part of the record here, right? I'm sorry, you were going to say, Mr. Stone?
I'd just like to add that my client's rights to cross-examine anyone on these documents with regard to the phone and who this is. It appears to be.
Which one are you looking at when you're saying this?
Exhibit 9.
Yeah.
Those two rights to due process.
So, quite frankly, I think I will learn. Well, let's see. Now that I've looked at the details of this.
This is pretty
Well,
incomprehensible.
it's obvious what its probative value is. All right. Well, I made my ruling on it. Mark, so the 10 and do the next
Yes.
page 625.
Yes, and I'm printing out hard copies for the
Parties?
Yes.
Yes, great. Thank you. And did you make a separate copy of the exhibit 8 for that was the one with the markings on it? Because we're going to make that a exhibit 8 right now.
Yes, I will print that out as well.
Thank you.
Thank you.
So a cross-examination objection to exhibit 9.
Continue now.
Judge seemed to
Your
say,
rights are saved, and we'll continue with the testimony of the chief.
That the probative value is,
let me check first. What is this marked as? 10?
Yes.
Yes.
Chief Holmes, when you were reviewing the evidence in the internal affairs investigation, were you able to access Cellebrite?
Yes.
And were
Objection, Your Honor. We'd like some foundation as to what is Cellebrite? Where is it from? What software is used? How it's
oh Lord.
Because as we go through the exhibits, and that's what you've seen from the exhibits, Cellebrite, assuming all these documents are downloaded somewhere, gives multiple images of the same email chain. So if I send a message that says hello, it comes up hello, hello. Again, in certain instances, we'll see it as we go along.
Well, and you'll be able to cross on it, but why don't you get some foundation on Cellebrite itself?
And perhaps his background.
may I conduct my direct?
You may, unless you want some more lessons.
No, that's okay. Do you mind explaining what Cellebrite is?
Sure. Cellebrite is an investigative tool for managing cell phone data. It's typically used in drug cases. It's run off of, at the time, it's run off of one exclusive personal computer with a large amount of storage because when you download the data, it'll lock up your computer, it'll freeze things up. It's a tool that you can be used with certain filters, certain search parameters, date ranges, all sorts of things. It's a very, very complex tool.
And what exactly was that?
The foundation is that they
Now-
use it in drug cases.
Had that information from Black knowledge been accessed through Cellebrite?
I think it's its own program. I think they're separate.
And is it fair to say that one of the benefits of Cellebrite is that it presents the data in a neater way?
Well,
Yes.
There's no objection. Objection.
Well, I didn't finish my question.
Well, it's,
Yeah.
in either way, the question is it leading, and it was leading, so it's objection sustained, even though we know what the answer is.
But what are some of the benefits of Cellebrite?
It manages the information more linear. It gives you different search features. It keeps all of the information really in one place for each data set that you pull. It's easier to use.
If you were to just receive a direct download of someone's cell phone data, would you just be able to open it on any computer?
No,
Are you personally certified as a Cellebrite expert?
no.
Were any of the independent investigators that Stoughton hired more experienced in Cellebrite than you were?
Yes.
Which investigators?
Sergeant Mike Bates.
Do you know what his background in Cellebrite is?
Yes. He's a forensic computer expert. He's very well versed in Axiom, Black Case, Cellebrite, all those investigative tools. Ran his own company when he retired from the Mass State Police.
Is that one of the
Another
reasons
one.
he was hired to help out on this investigation?
Yes.
When you were reviewing the evidence, did you frequently consult with the independent investigators?
I did.
How often?
In the beginning of using Cellebrite, I had Sergeant Bates in every other week. He talked me through a lot of different search type engines on the phone. Lieutenant Fanning is also well versed in it, so he gave me a lot of assistance.
And Lieutenant Fanning was currently active in the state police.
Yes.
So Fanning's an expert with this data. He's an expert in being able to go through this data, and he apparently missed the data that showed the evidence of the sexual relationship between Farwell and Sandra Birchmore when she was a minor that would support a criminal prosecution. He apparently missed that, this expert. How peculiar. Wonder how that could have happened.
Now, you mentioned that there was an interview of Mr. Devine during the internal affairs investigation. Is that correct?
Yes,
Who conducted the investigation?
Captain Littling and Lieutenant Price.
Was there ever a second interview scheduled?
Yes,
Did a second interview ever take place?
no,
And why not?
the Robert Devine had retired.
After he retired, was there any way that you received additional information from Mr. Devine?
Yes,
And how was that?
first class mail.
Uh,
It may have been an email as well.
but why did he send you something?
I had sent a series of written questions because he had indicated in one form or another that of course, he's going to cooperate with the investigation. And the investigation now protracted into whether or not he was being truthful in his initial responses in the first interview.
Mhm.
So then I had sent a series of questions by first class mail and I received a response.
Can we go to page 227 in Exhibit 1?
Yep,
Do you
that's what
recognize
we
this
said.
document?
I
That's
do.
why he didn't
And what
want to
is
do
it?
that second interview.
Was this why did you send this letter?
He indicated to me in one form or another, again, it could have been an email. I don't remember, but he said, of course, I will cooperate with the investigation. And then he had said, any further correspondence, send it to me by mail. So I did that.
What's contained within this document? At this point, since Mr. Devine was retired, could you order him to participate in the IA?
No,
On this page, can you please read the first question on 219? Or sorry, 227, my apologies. Did Mr. Devine ever respond to these questions?
he did.
Can I ask that we move to, sorry, just one moment. We move to Division Exhibit 1 and I think it is, sorry, Your Honor. 251. And then can you turn the page to, yeah, so it's beginning on 251. Do you recognize this document? It's the next several pages as well.
Yes.
What is this? Now, did Mr. Devine respond to all the questions that you had asked in your letter?
I'd have to review the documents. I'm not 100% on whether or not he answered all those questions that I sent.
Do you remember in substance what his response to the allegations was?
His account got hacked and
Was that ever a concern for you here?
no,
Why not?
A lot of stuff
Did
we
you
don't
ever reach any
hear.
conclusions as to those primary questions?
yes,
And did you believe Mr. Devine to be Marty Riggs?
yes.
What did you base that conclusion on?
Based it on the data that was in the Cellebrite, I based it on the context of the conversation that he was having with SB. There was nobody in the department who was in law school, to my recollection at that time, or that had just recently passed the bar, and that was the subject of some of the conversation. There's additional conversation about whether or not she was expecting a child with Matthew Farwell, and the response was something along the lines of, you shouldn't be talking to me about this. You shouldn't be talking to anybody about this.
May we go to Exhibit 1 on page let's do page 30, or excuse me, 26. Now, beginning about midway through the page, do you see a heading marked findings? On 26 should be the bottom middle page number.
Yes.
So what is this portion of the document we're looking at? Can you go through your findings as to Officer Devine?
Sure.
We don't get to hear.
Generally, what
IA
was
report.
the alleged conduct underlying this allegation? Were any of his alleged interactions with SB, did they occur while on duty?
We believe so.
And what makes you believe so?
There was reference to meeting locations, and that was something that SB would do.
Was that within the correspondence of Marty Riggs?
Yes.
And what was the next finding after the incompetence?
The next finding was untruthful in violation of Section 4 of the Rules and Regs, and that was sustained. He did not.
And is there another finding that you came to in regard to Mr. Devine?
Yes.
And what is that?
Because
where is the Chateau restaurant?
Route 27 in Stoughton, about a quarter mile from the Brockton line.
Would it be within the patrol area of the Stoughton Police Department?
Yes.
Can we go to page? Just one moment, my apologies.
So we didn't get the
I
explanation,
did.
but we know he thinks the hack is a bunch of crap.
So can we go to page?
Internet issues.
Okay, can we go to page 172? Do you recognize that?
Yes.
And what is it? Okay, and can you direct your attention to page 182? So what does that mean? After Mr. Devine became involved in the investigation, do you believe that there was any point at which you had personal bias such that it would exclude you from investigating this case?
Objection, ask and answer. Fine. Ask and answer. I'll allow it. Go ahead. You said no?
I did, Your Honor.
Nothing, break.
Oh boy, how long? We got about 30 minutes,
No.
30 minutes with this defense lawyer.
He testified that Mr. Devine retired, is that correct?
Yes.
Oh, first all the way back up.
Actually, Mr. So, I'm sorry, but remember the recording issue? So
Sorry.
I know you're not used to it.
You just talked about times that Mr. Devine worked. Where are the timesheets?
They're not included in the case file.
They weren't included in the IA report, right?
Correct.
They're not included in the case file, correct?
Correct.
So you're just operating off of memory once you believe in what his hours were, correct?
No,
You never provided them a copy of the time records, did you?
they didn't become a part of the case file.
So let me go back, sir, now. You did your investigation of Mrs. Devine. And I go to 1402. Looking for my. 1402.
Yes.
And is there a reason why it hasn't been provided in this instance, in this case?
I don't know that it hasn't.
Did you provide it to Post?
I gave Post everything that was in all the case files. I can't tell you sitting here today whether that was included or it's not.
Is included in your IA report?
It should have been.
With regard to the next page. 1404. What is that? There was one created for Mr. Devine,
There should have been.
has been provided.
I gave counsel everything that I have in my case file.
With regard to page 1405. What is that? Was that provided to council?
It should have been.
And how about page 1406? So will you agree with me that when you do an investigation, you have to be unbiased about it?
Of course.
Now, you've had a history with Mr. Devine, have you not, sir?
Sure.
And as part of that history, you had an altercation with his daughter, is that correct?
No.
Well, did you find that his 8-year-old daughter had been to this police station and wrote words with a crayon on a piece of paper?
Yes, I found a document in there and the chief handled that as a personnel matter
You find a document in where? Where was it found?
in my department mailbox.
It was in your mailbox. Okay, what happened with that? What happened with the investigation?
I think the chief had one of the lieutenants look into it, and his daughter was not allowed into the building for a certain time period based on what she had put in the letter.
Okay, what did she put in the letter?
Revenge is a meal best served cold. I don't know. It was in crayon. It was children's writing, something like that.
That's a quote from Star Trek, Wrath of Khan, isn't it?
No, it's a quote from Man on Fire.
Arguing about what it's a quote from. I don't know what it's a direct quote from. Man on Fire. I don't know what that is. The attorney seems to be saying it's from Sartre, Jean-Paul Sartre, French philosopher. I don't know if he said that or not. It seems like a more literary thing, but revenge is a meal best served cold, written in crayon by the 8-year-old and put into his mailbox. That's odd. That's odd. Why would an 8-year-old write that? Why would an 8-year-old direct that at him? Was this just all? Doesn't seem like it was just all innocently explained because the daughter was banned. It really seems like, this was Devine kind of using the daughter to do this and then throwing her under the bus, making her take the fall for this little prank.
So
I hate to interrupt your cross-examination, but I don't want to be the only one in the room that doesn't know what Man on Fire is.
It's a Denzel Washington movie, Ron. It was pretty good.
What was it?
It's a Denzel Washington movie.
Oh, is it?
Yeah. A lot of violence.
I thought I was read the ball first.
Didn't see that.
I needed to know that too.
you didn't take Mr. Devine's first interview. Because why? What was the reason?
Just keep it clean. I figured he was going to make an allegation that I had some sort of bias against him.
You had a history with him. You describe your animus, if any, against Mr. Devine?
I mean, I wasn't happy with what materialized with this case, and as a matter of fact, nobody at 26 Rose Street was happy with what happened. But I mean, like I said in the beginning of my testimony, met him in the academy. We were good friends. We stayed good friends. The job changes your relationship sometimes with the subordinate relationship. Didn't agree with some things that he did. He had made personal lifestyle choices that I choose to not be involved in, to keep my life simple. We put safeguards in place to keep any bias out of it.
The personal lifestyle choices of what? Why was that? Why'd you have a problem with that?
I just choose to not associate with people in my life that do that sort of thing because it causes complications.
And when he was coming back to the department after the incident in 2015, were you part of a vote to try to not have him come back?
No.
Was there some sort of vote done in the department about his coming back?
I mean, it may have. I'm not sure. There was later action against the town manager involving his role in the decision to. He wanted Devine fired. The town manager did not. So the union at one point in time, they voted no confidence in him. The town manager, that is.
Now, you were just talking about and he actually raised that objection. He says there's a conflict that you have.
I'm sorry. What are you asking me?
Yes, sir.
What?
Are you raised the issue that you have had a conflict of interest?
Without a doubt, I'm sure he has.
So you knew that was going to come, right?
Sure.
Okay. So you didn't recuse yourself from the investigation, right?
Nope.
Now, you testified that the Marty Riggs file. Oh, let's back up. Let's go through.
Sorry, I keep standing. No, you can stand. Just when you're talking, need you near the mic.
I'd like to go to page 14.
More documents we don't get to see.
So when you did the investigation, you had a couple of assistants.
I did 3.
So that's what we should expect to have in all of these, right?
I didn't hear the last part of your question, sir. I did.
And who was that?
The attorney that represents the estate of SB.
An attorney from Marullo provided you the box of documents. Is that correct?
Yes.
Provided a box of documents.
You did an investigation into him as well?
I did not.
Who did the investigation into him?
Clifford and Kenny.
Who's Clifford and Kenny?
The law firm that represents the town of Abington.
So an outside law firm handled the investigation of Mr. Hume?
To the degree that he was the target of it, yes. He was a witness in this case only.
Well, as part of this case, there was DNA tests and everything else done at the kennel where he worked, because he was a dog officer, right?
Right.
So he was a suspect.
He was a witness for us. He was not an employee at the time where he was interviewed. He was compelled by rules and regs of his own department and ordered by his chief to cooperate with the investigation, which he did. And then their chief made an inquiry into whether or not he should have been suitable for employment there. And he ended up leaving that department.
So they're talking about Josh Heel.
So you were part of investigating the death of it.
No,
And why would you say that?
I had no jurisdiction to do that. As I answered in a previous question, My internal affairs investigation concerned policies, procedures, rules, and regs of members of the department. And any such evidence of a crime would have been referred right back to Lieutenant Fanning.
By the way, do you know what Officer Robert Cohn
Kuhn, K-U-H-N, yes.
went to law school?
He did,
Same Robert, right?
yes.
Where did he work?
He's a detective at the Stoughton Police Department.
Well, earlier you testified you didn't know anybody who else was in law school from the Stoughton Police Department, did you?
At that time, correct.
At that time, what do you mean, 10 minutes ago?
At the time that Officer Robert Devine was in law school, I don't believe anybody else was in law school. Detective Kuhn ended up going as a military veteran on the Gold Star program, and he's a practicing attorney in Plymouth County right now.
He's practicing attorney in Holmes County right now?
He is.
He went to law school, right?
Sure.
So it could have been somebody else in Stoughton Police Department with the name of Robert or Bob or Rob or whatever it might be, who was in law school at the same time as Ms. Birch, 2020, right?
Sure, they could have been. If I misspoke, I misspoke. I explained that. My recollection is that there was only one person finishing law school or in law school at that time that had passed the bar, and it was conversation to that context.
So you could have been incorrect in your statement that there was nobody else in Stoughton Police Department who was a member of the bar going to law school, correct?
Sure.
Judge is taking a note of that. Because the context of the messages is important.
Is that correct?
I don't know. I'm sure that we talked about it.
Page 719. 2/3 of the way down. Now, is it important when you're drafting an internal affairs report to include information that is both harmful and helpful as a neutral party?
Yes.
Is it important to keep the entire file together so the person coming in behind you gets the opportunity to see that file?
Yes.
For this conversation, may the witness be briefly excused?
Yes, would you step out for a moment, please?
Yes. How long do I have?
Long enough.
Taking a break for argument.
I turned the information over that the post commission had, similarly to with McNamara's cross-examination. They said that a transcript exists and it wasn't in the discovery. That means we didn't receive it. So
That's what I thought.
There are many transcripts, Judge, that we didn't receive. I was going to go through them all because they might all be exculpatory and we never received them.
Well, it's not for lack of, I'm confident it's not for lack of the division not providing them to you, but the question is, did they end up post somehow? And I don't know, presumably everything post got, they got from you. I mean,
you're saying for me?
Yes, I'm sorry.
Yes. I've been at post since the beginning of this case. I reviewed files several times before compiling discovery, and I 99.99% sure, as sure as I can be, that all the materials were disclosed to Mr. Stowe. And I
0.01, I should be worried.
I would be worried about that 0.01. I don't think you should be worried. I double checked discovery. Like I said, I represented this back in March of last year. I believe that Mr. Stowe has the entire case file that Post is in possession of.
I would agree as far as you're concerned. And for example, it doesn't include the transcript of her interview.
Correct. The only written transcripts we have are the heel ones that were included.
Okay.
Yeah.
And that would seem also to be true, just so because we're having this discussion with the documents that are part of the waivers, et cetera, for the IA policy, the IA policy.
Yes,
I haven't seen completed.
I have not seen it, no.
And if I may, Judge, Mr. Devine hasn't even seen his own transcript. That's not here.
Well, that's not included in the report either, right?
He discusses it in the report.
What?
We haven't gotten there yet, but he discusses it.
But the document itself.
Oh, yeah, no, it's not included.
Travis, not yet?
Yep.
That as well. That's all, something I'm gonna have to consider as I go along. I will, however, so that we can be complete, make an inquiry of the commission about, what they received from, the division, so I can confirm that somehow in the process, they didn't get something that, we now think they didn't get. You know, that like these transcripts or something like that. So I will do that. I want to be satisfied that they never got, they don't have it. We don't have it. Post doesn't have it either. So I will look at that. I think I have the right to do that. And I will make that inquiry. But it's not part of any file I've seen. I haven't been presented with that submission. I usually am not, because I wait to see what evidence is introduced in the adjudicated hearing. Right. But I certainly will follow up on that.
Thank you.
Should we bring him back when he's back?
Yes, we should bring him back when he's back.
While we're waiting, about how long do you think you'll be with him from now?
I'll be a while, Judge. There's a lot to get through.
Be a while. Great.
Not mention Mr. Devine at all. Is that correct, sir?
Not to my recollection.
Next witness, Julia Evan Curley, age 45. Ms. Curling had contact. Nothing going on. Do you know if there was a transcript of that interview?
She never actually got interviewed. I did, Your Honor, and if I...
That's it. I just want to know if you wrote that. Thank
I
you.
did, yes.
And you testified earlier that Mr. Devine made statements to you in that interview. That he thought his computer was hacked. Is that your testimony?
Testimony was that I didn't interview him. He was interviewed by Captain Lilleen, and that there were statements that he made during that first interview that we characterized as untruthful.
And you said that he presented an issue that his computer had been hacked, his account had been hacked, correct?
I know that he's made that overture in the past. I'm not sure if that's what came up in the first interview.
Where's his interview transcript from his first interview?
I provided it to Post.
Say it again.
I provided the transcripts to Post. I gave everything to Post.
Mr. Devine, would it surprise you to learn that Mr. Devine said that he didn't have an account during that interview?
No.
Okay. So that's a lot different than my account got hacked versus I didn't have an account. Would you agree with that?
Yes.
Just for clarity, there are transcripts, and the transcripts are made because they're recordings and they're made from recordings. Is that what you're saying?
Yes, Your Honor.
So where are the recordings?
They would have been preserved on a thumb drive and included. I think that they're a labeled exhibit in my case file.
So I'm sorry, in the what?
In my case file.
And are you saying that's also part of what was presented to Post? The recordings themselves?
Yes, sir. Post has everything that I had in my case file.
So both the actual recording and the transcript of the recording.
Yes.
For each of these witnesses we've talked about that actually were interviewed.
Yes, Your Honor. I saved every recording and redundantly had them transcribed.
And you testify that he denied having any contact with SG, correct?
I believe so.
Okay. Page 47, middle of the page.
Sure, that's accurate.
Yeah, that's accurate.
Yes.
So your testimony earlier that he claimed he had no contact with her, is actually incorrect. Is that correct?
Yes.
Did I read that correctly?
You did.
So your testimony that there was no contact is contradicted by the statements you wrote on page 47, correct?
Objection, asked and answered.
No, overruled. You can answer.
Yes.
It's not attached to this exhibit, sir. What is
It's a whole
T3?
separate binder.
Whole separate binder.
Yes.
Well, just so I understand, when you have a designation T3, what does that refer to particularly?
Your Honor, I had two binders. One was the case file and a whole bunch of evidence. The second one was all transcriptions. They were both about that thick.
So that would have been the third transcript in that binder.
There's two series, so anything labeled S was a state police report or transcription of anything that they did, and then anything that I did for interviews was labeled as a T transcription. So that would have been T3 would have been just where it fell in the order.
You say that also would have been provided to counsel and to the commission.
Yes.
The next person,
Just to clear, so I make sure I have the whole picture, as well as the recording itself.
Yes.
what is on the spectrum mean?
A reference to anything on autism spectrum disorder.
Okay. It has,
Don't know who's on the spectrum because we don't get to hear.
who's a DARE officer? What's a DARE officer, sir?
Drug abuse resistance education program started by First Lady Nancy Reagan. It was federally funded.
Is that correct?
Yes.
Now, throughout your investigation, you've never come across anyone who has told you they saw Mr. Devine with SB, correct?
That sounds accurate.
So you have no phone calls for Mr. Devine to SB, correct?
Spectrum is anything on the autism spectrum disorder. Asperger's, autism, any of those things.
At that time, there were a few people named Rob in the department, right?
Sure, that's at
Rob,
least one that I can think of.
Rob Coombs, Rob Dentry, Robert Coon, right?
Lieutenant didn't go by Rob ever, but Rob Coon, of course.
Different people call different things by different people, don't they, sir?
I don't know a single person that ever referred to Lieutenant as anybody but Emmett.
Now, sir, the next. Do you know that?
I don't think I ever saw a record that he was working a midnight shift.
Right. He didn't work midnight shifts. So that,
Your Honor, we're getting to the point now that Mr. Stowe can read whatever text messages he wants that are in evidence during his closing, but I feel like we need some more substantive questions here. He's been reading the report, reading the text.
Well, either way, he has to have questions.
Yeah.
yeah.
I mean, you're just reading occasionally, ask him, am I right?
I'm reading it, Judge, because this all leads up to a claimed sexual event with.
No, I get where it's going, but
Then
my
it changes. And that's why they didn't introduce it, because they realized that SB lied about relationships. So that's my own problem. So
what I'm requiring is that there be some question and answer, as opposed to us sitting here listening to you read to all of us.
now there's a change in the tone.
Wait a second. Do you understand what I've said now 3 times in a row? This is questions and answers. I didn't say it's not relevant. I'm telling you, though, that in a evidentiary hearing. There must be questions and answers, not you simply reading this.
And at the top of page 502,
Objection, Your Honor. We're again just reading the text messages here.
Well, but I understand it's a predicate to an inquiry, and I'm
And this is
allowed
where-
to do it as long as he's doing a question and answer form. I'm going to do it up to the point it is obvious it has no probative value, and so far, I can see the probative value.
So just going through lots of chats.
did I read that correct?
Yes,
Who's Jenkins?
safe to assume it's former Sergeant Dean Jenkins, who's no longer with the department.
So, did you investigate Officer Jenkins for having sex with her?
Yes,
Okay. And did you do it because of this exchange?
I don't remember why. His name was mentioned. I don't remember if I read it. I don't remember if somebody told it to me. I did several.
How much longer on this topic do you think you have?
I think with this topic, when we have a change in the story, I think this is getting close. It just gets into how she got to this house, which is,
Time-wise, I'm trying to ask.
like 5 minutes for a change of topic.
Because we're going to shut it down then for today, because I need a few minutes with you folks. After we postpone till tomorrow. Recess till tomorrow.
Your Honor, I have a couple scheduled conflicts. I don't know if we can work that out with Mr. Sean Martinez.
Why don't you just answer this question quickly? Did you look at the last couple of pages?
I did. The answer is it looks like the same discussion thread.
Okay.
So the same person is being discussed as this person, Rob.
It appears so.
So let's do this. Remember where you are. Since obviously you're not, well, based on what you said so far, it's apparent that when you finish with this line of questioning, you have more areas of questioning for this witness.
Yes.
Give me a clue about how much time you think that will take.
Couple hours.
Couple of hours?
Yeah, or perhaps hours, yes.
Well, if it's for the benefit of reading through all these, we need to talk about that. There's another way of doing that. These documents are evidence. I certainly can read them as well. It's my responsibility. Not that I'm looking forward to it, promise you, but I'm, so we have to talk about that. But, Chief, what's your schedule issues tomorrow?
I'm at executive training all week. I actually, to accommodate post, I decided to forego 1 day of training. Tomorrow's the last day.
It's a full day of training.
It ends at about 1:30.
And where is this? So I have a sense of
Cambridge.
Scheduling.
Cambridge.
Yes,
Can you come here directly when it ends?
I can.
We'll probably interrupt this. What else do we have scheduled for tomorrow?
I believe only Mr. Devine's witnesses.
You're putting on Mr. Vine?
No, I don't believe so.
Oh.
I'm putting this.
So you have other witnesses as well?
I subpoenaed 2 other witnesses. I don't know. I haven't heard back from my phone numbers.
Just remind me who you're talking about. All right. So let's do this. I'm going to let you go. I'm going to excuse you to 1:30. Getting here from Cambridge at that time of day shouldn't be terrible. It's never good from Cambridge to Boston.
But thanks for the accommodation, Your Honor.
And we'll do what we can accomplish tomorrow. I want to have a conversation about that now. So I'm going to excuse you now, Chief. Obviously, you're subject to the protective orders. Please remember that. Don't discuss your testimony with anybody.
Thank you, sir.
All right. Thank you.
Are they done? No, there's still something going on for another 10 minutes.
All right. Before we get anywhere else, I'm a bit concerned and intend to follow up on the whole issue of the missing recordings, transcripts, etc., and we'll determine whether that which was received by the commission originally, contains any of that material at all. I think it needs to be, even beyond the context of this hearing, it needs to be determined for obvious reasons, at least to me, obvious. But it also struck me that nobody has listed, and I can understand in the context of the nature of this proceeding, but nobody has sought to secure the testimony of these freeze. So in some sense, I can see why it's unnecessary in the division's context that given they have the report, et cetera, in an effort to prove their case. I can understand that. But given the developments regarding the record in this case and having to determine ultimately the credibility of the evidence that's been presented to me, the question is whether they ought to be in this room, whether we ought to make a record of whether they in fact recorded interviews with these folks, whether they had transcripts prepared. I'm not saying it's convenient for him, but he's presumably relying on what he's told by these other investigators. And the contents of many of these interviews on which this fellow made a determination, and the investigator thing relied entirely on his fellow investigators, is an issue. The credibility of it is an issue. So I just want your reactions. I'm going to start with the division about the notion of having, particularly, I don't know how to pronounce his name. Is that right? Actually, I'm saying a good yes, and I know you know.
They pronounce it.
Well, they don't know. we know. But what do you think about that?
So if the reason that these investigators are being called is to speak about the interviews, I do think that requesting specifically the written and audio transcripts would be a more effective way of doing so.
Well, it kind of answers the whole question if they exist. Oh, I mean, if these folks have these sitting somewhere,
right?
I want to see them.
Yes, I wonder.
They're entitled to see them, and they're going to argue, wait a second, we should have had these a year ago.
I will say, first of all, the other side also did have subpoena power throughout this entire proceeding. But second, I do think a subpoena to Stoughton may be more effective than calling in. If that's
well, I didn't ask, and nobody asked whether he sent this on but preserved copies at the department, which would, when I was still trying cases, I would have remembered to ask that question. But you get lazy as a judge; you don't have to ask those questions. Well, but I'm serious. I didn't ask that question because the impression I was getting was we shipped it all out to them, and we don't have this stuff anymore. That's sort of the way I was hearing it, but that may not be what they would say ultimately. But I one way or the other, I'd like to find that out. And it may mean that we have to go through that process before we ultimately conclude this hearing. How do you feel about it?
That makes sense.
All right. We have one scheduling problem. See, he's not the only one. I'm gone from Sunday till the 19th of the month, and I'll be overseas. So unless you all want to join me in London, there's not much I can do about that. We'll just have to reconvene after that if there's more evidence that needs to be taken. I don't know how, we're here at 5 o'clock. I don't know how quickly they're going to respond to a subpoena looking for documents buried in their, if they exist, buried in their files. I am making an inquiry through my colleagues here about what the commission received. to make my own sort of internal investigation regarding that to see if there were recordings or transcripts that were received. But it's important to me in terms of the integrity of the process, number one. But in terms of Mr. Devine's case, it's also important because it's based on this information that he's purportedly getting from investigators that shapes the conclusions that he makes about Mr. Devine's credibility and the strength of the evidence against him. And I think we'd be remiss if we didn't make this inquiry. So I'm happy, since I don't think we get to them under any circumstances tomorrow, to put it on you, Ms. Martinez, to, in the first instance, approach it by way of a subpoena. I'm okay with that. But if you get and press for a quick response, and, this isn't looking in the files of the FBI, it's just Stoughton's police department. And secondly, if it doesn't exist, to consider at a minimum, as I look at who seems to be doing more of these interviews, I mean, they're both doing it, but I would say if they don't have him, we ought to be subpoenaing him to appear in this proceeding, unless somebody persuades me otherwise. So what we'll do is we'll interrupt the cross of Chief here, and it would be your intention then, and after his testimony, you'd be resting.
But barring the receipt of the transcript, that we continue the hearing for that reason.
Yes. Okay.
Yes.
And certainly I allow you to reopen if that new evidence came in unanticipated. So would you be prepared to put Mr. Devine and anybody else shows up in the morning?
Yes.
Okay. Let's do it.
Sorry, just to be clear, that's prior to us closing our case. That's okay.
Yeah, that's a question.
That's the question, yeah.
But your case is really your cross. I mean, the balance of their case is principally your cross. There may be some redirect. I understand that. So, and these, if this were a criminal proceeding, for instance, I might have one reaction to it. I'd have to understand from you why you think your client would be prejudiced if I had you go forward, even though the cross wasn't completed.
Right.
Are you, so you want to think about that?
Yeah, I think I'd rather finish the cross.
Well, it's the rather, and that as opposed to the entitlement to or the need to. I understand. I'm not, your point is well taken. I'm sure if I were sitting in your shoes, I'd be saying the same thing. But I just,
May I make a suggestion?
Yes, sure.
If I don't anticipate crossing the two subpoena witnesses very much in the morning. If we could do those two witnesses and hold off on Mr. Devine's testimony until after the cross of Holmes, and after the receipt of the transcripts, maybe that would be.
Are you okay with that? Putting out if those two folks show up?
Yeah, put one first, yes.
Yeah. Again, who are they? You said that. Are those two of the people that were interviewed as part of?
They actually have affidavits contained within Mr. Devine's responses.
Okay. Oh, all right. All right.
I didn't hear that.
I'm all
Who
right.
they are.
That makes good sense. All right, we'll do that first thing. You're direct on them. How long do you think that might be?
Oh, half an hour with them, maybe. Half an hour, 15 minutes with you.
You don't consider the cross to be extensive?
I don't anticipate so unless information outside of the affidavits comes through, but it doesn't seem like there's too much that I'd be crossing out.
Okay, so I'm just thinking of the timing of it. I don't want people to have to be sitting around unnecessarily. But I want to make sure they're completed by 1:30. Well, he gets done at 1:30.
We probably wouldn't actually start at 1:30.
Yeah, I wouldn't think so. Because it's closed. Um, So if we get lucky, he's here too.
Yes.
Right?
He did get here very quickly this morning. It was like 20 minutes, less than 20 minutes.
And my guess is he's motivated to get this done, so, that's, just a wild and crazy guess. All right. Let's, well, how about we start 10:30 tomorrow? Does that work for everybody? Is that all right?
Yes.
10:30 here? Tomorrow. That'll assure us, I think, the ability to get completed with those two witnesses, be ready for this witnesses balance of this cross, and we'll take it from there.
And Your Honor, may I speak with Chief McNamara? I don't anticipate recalling her on rebuttal or anything, but to coordinate the transcripts.
In the issue of the transcript.
Yes.
Yeah, I would prefer you do that. Before they get a subpoena, they should be looking.
Yes, okay.
Yeah,
I'll reach out to her. Yes, I'll reach out to her immediately.
Yeah, thank you. All right, anything else anybody wants to bring up this time?
No, Your Honor.
See you tomorrow morning.
All right. See you tomorrow. So today really characterized by these evidentiary management issues, aren't they? First, we had that long interlude with sorting out the Cellebrite and defense claiming they've never seen this exhibit before, and the Mr. Martinez, the division's lawyer, saying it's part of this exhibit, and we gave you the Cellebrite reader software, and your inability to read it was not our fault. And he's saying you said you couldn't read it either, and Martinez is saying that's not true. So that one ultimately resolved in favor of the commission. The judge did go ahead and admit the screenshot of whatever it was. We don't even know what it was that caused such a kerfluffle. But it had to do with something indicating a link between this Marty Riggs pseudonym and Robert Devine. And so now we're seeing where the defense is really focusing in on that aspect of the 2021 IA investigation, trying to attack that from multiple angles. Certainly procedurally, if they can just get the stuff thrown out, that's great. Yeah, you do that. Try to undermine the commission's case that way. And, it just really speaks to the importance of conducting clean investigations and being thorough with your disclosure. Open file policies. This is why they're a good thing. So you don't get into these back and forth disputes about, I didn't get this, I didn't get that. Were you entitled to it? Were you not entitled to it? Who has it? When was it provided? Did it work? Just give them everything. And so now the second issue has to do with the transcripts of the witnesses. And so they weren't attached to the IA report, which to me, that doesn't seem to raise any red flags. Like, you don't need to necessarily attach every single piece of evidence, but you should have it available. And so if all you have are officers' recollections of what was said during those interviews, well, that creates a whole different issue vis-a-vis the credibility of the reports of those officers about what was said, and the potential that witnesses might dispute that, might disagree with that, particularly when the witness is the defendant, Mr. Devine. He's probably going to take issue with the claims about the statements he made if you don't have a way to back that up. And so, according to Mr. Holmes, standard procedure, you would always tape record it, and then you would create the transcript as a redundant backup. But the problem is that none of those transcripts or recordings have apparently been provided to Post or to Mr. Devine's lawyer. And so the attorney for Post is saying, I don't have them. 99.99% sure they're not in the file. Holmes is saying, I gave them to Post. I gave them everything. I had this binder, these separate binders. One of them was just transcripts, and all of my materials went to post. So there's been, some kind of best case scenario misplaced. Some items were misplaced, but it's unclear. And so the judge, I think, is legitimately concerned, fairly concerned, because, the reliability of those statements is going to be fairly important in evaluating the conclusions that were drawn on the basis of those statements. And so were those conclusions reasonable? If he didn't have a transcript to rely on and was just, taking the word of the officers, that creates a whole different issue about the credibility of those conclusions as well. So the fact that they're positioning this as a bias issue, which I thought it was kind of funny that Mr. Holmes, the investigator here, just kind of leaned right into that. Yeah, I knew they were going to make that accusation. I knew they were going to do that. Saw that one coming. I mean, yeah, you kind of do. You kind of do. We saw with the way that Mr. Devine was kind of presenting his defense yesterday. He really does come across as one of these guys with a whole bunch of, explanations for everything, a whole bunch of excuses for things, a whole bunch of finger pointing at other people. He's never the one at fault. He's the victim. Just the women won't leave him alone. Poor guy. He's been hacked. Poor guy. All of these different things. And so, with somebody like that who's constantly evading accountability, you can definitely anticipate when they're going to try to manipulate the situation, try to capitalize on the fact that this guy doesn't like you anymore. This guy thinks you're a scumbag. And try to use that to avoid consequences. That's what they do. So I thought that was a little bit amusing that he kind of leaned into that. But the problem is that it is an issue the judge now has to decide, and so the judge has to evaluate his bias in light of what he relied on in reaching his conclusions. And that's a real different situation if it's I relied on hearsay reports from my officers versus I had the transcripts myself. I had the recorded interviews myself, and all of this stuff can be substantiated. So, when they don't run a clean investigation, when they don't properly document stuff, these are recurring problems we heard about throughout the Karen Reed case. When they don't fully disclose the materials they have in their possession, it creates these issues, and it runs the risk that somebody that is a wrongdoer is not going to be held responsible because you didn't do the job you needed to do to get through the process in a fair way. So, other than that, there wasn't really a lot here, I think, that we didn't already hear from Chief McNamara. We just got a little bit, I guess, more detail about, didn't like him, thought he was arrogant, was way too cozy with another former explorer besides Sandra Birchmore. She was an adult, but a little too cozy. Gross. These guys are just gross. And then this issue with him being a cooperating witness for the defense against another indicted police officer, but then backed out of that. So they had disagreements about that. Ultimately, some other stuff, he decided he just wanted to distance himself from Mr. Devine's personal issues so they didn't complicate his life. We didn't get to hear what that was. But if we take it from what Chief McNamara had to say yesterday, it's his cheating. He's cheating. And when you're cheating, you're typically lying about your cheating. And then you might, need other people. You might be trying to rope other people into lying for you to help cover up and things like that. People who value their integrity don't want to be anywhere near that. But so it does create a question of, hey, if you already think this guy is a lying scumbag, then you're going to be inclined to believe he's a lying scumbag. And so did that affect your investigation? If so, how? And seeing what he relied on could be a pretty important part of resolving that question. Is this a reasonable, unbiased conclusion, or was he just looking for, is this just confirmation bias? He was looking for things that would substantiate what he already thought about Robert Devine. So yeah, boy, this whole bunch of my notes are all just about this Cellebrite back and forth, and the challenges of educating a boomer tech neophyte about how Cellebrite works and how to navigate it, and who's at fault for a defense attorney's claim that he's never seen this particular item from the extraction before. So then the belief that Devine was Marty Riggs was based on both Cellebrite data and the context of the conversation with Marty Riggs, based on the fact that nobody else had been in law school or passed the bar exam. So he believed that those were facts that only applied to Robert Devine at the time. Now, the defense is suggesting there's this other Kuhn. It might have been Kuhn, because Kuhn is now a lawyer. But we don't know the time frame. But the witness, Mr. Holmes, kind of conceded, yeah, maybe I could have been wrong about that. I think you want to get that pretty clear, your basis for that pretty clear. If it's in his report, the basis for why he thought Robert Devine was the only one in law school at the time, then the attorney is going to be able to redirect him on that. But if it's not, that could potentially be an issue. I don't know if it's a total issue, because we have such a hard time sorting through the basis for all this when we can't see the documents and we can't hear a whole bunch of the questions about the documents. So we don't know what the text communications are. We don't know, what the conversation with the Cellebrite data that is so damning. We don't know what that's based on. The defense is also starting to go down this line of suggesting that because Sandra Birchmore lied about some relationships, that perhaps she lied about Mr. Devine as well. And we didn't get to hear a ton about that, just kind of a hint that she just that she'd been dishonest about her relationships. So then we're just starting to turn to this issue that Devine apparently claimed his computer was hacked, that he'd made that statement before, and that they characterized statements from his first interview as untruthful. He wasn't sure, I think, if that statement was made in the first interview. This, again, is just part of the complication of not having transcripts to be able to nail down. If you're saying this in your IA report, that this claim was made, then you really need to be able to back that up. And it sounds like the materials that have been provided so far don't do that. It's just kind of a trust me, bro. And that's why the judge is saying, look, at the very least, this guy that conducted the interview, you need to get him in on the stand, because he's going to have to testify to that. There's apparently an inconsistency about Devine, whether he said he had no contact with Sandra Birchmore or not. He apparently said, this witness Holmes said that Devine had said that, no contact with Sandra Birchmore, but apparently later on in some other document, he contradicted that. He acknowledged that that was a contradiction. So that's not particularly helpful either. Somebody's on the spectrum. I don't know what that has to do with anything, but I couldn't tell if that was part of the conversation or what exactly that was about. Nobody said that they ever saw Robert Devine with Sandra Birchmore. So if he did it all on the down low, that means it didn't happen, I guess. No, I don't know. But they're just using that as trying to circumstantially establish that Marty Riggs, Rob, these people were somebody else and not Robert Devine. Yeah, so Stowe is claiming that these text messages, they're having an issue with they're doing a Ben Rottenborn from the Depp trial, just reading the messages, and the only question is, did I read that correctly? That's not proper questioning. The messages are, in this case, they're already in evidence, so you only need to be bringing up to ask him something about them, not to just draw attention to them. So they disputed a lot about that. But ultimately, the defense lawyer, Mr. Stowe, pointed out that this is all leading up to a claimed sexual incident, but that they realized that Sandra Birchmore had lied about some of her relationships. So I don't know the context about this. It's just part of the frustration, the limiting factor of not being able to see so much of the substantive facts, the documentary facts, and so forth that the commission is relying on to be able to make this decision. So I don't know. Maybe she did. Does that mean she lied about this one? I don't. Maybe not. We just don't know. And then there was another person, Dean Jenkins, who was also apparently investigated for having a relationship with Sandra Birchmore, but he is no longer with the department. I wonder what that's about. Sounds like that's somewhere in those investigative materials that we may ultimately find out about somewhere in the course of the Farwell prosecution. But if they're in the Fed's possession, I don't know if we'll get to see them. But if he's saying that Brian Holmes, Stoughton police, they investigated this guy, those should be available. Does anybody know? I haven't heard anything about Sergeant Dean Jenkins before. So if this is one of those things where IA, misconduct claims, maybe like this, are no longer protected, they're no longer considered personnel files, then they're not confidential and they should be publicly available. Maybe a little PRA request is in order, public records request. I don't know, something to think about there. So we'll be coming back tomorrow. They are going to need to break, apparently, the cross-examination of Mr. Holmes because he's got a training over in Cambridge. And they're going to take some of the defense witnesses out of order. This is the plan anyway. Who knows if this is going to go according to plan? Sometimes it doesn't. Maybe the cop will just decide he doesn't really need to go to that training. He skipped it today. Maybe he can just skip it again tomorrow. I don't know. We'll see. But a little stronger day for the defense. This one, I think. Not just on the procedural battle. Of course, they lost the one with the Cellebrite, which seems like a pretty big loss. But they've definitely gotten into the judge's head about this issue with the transcripts, and I think fairly so. If we've got to be able to evaluate Mr. Holmes's bias, then we need to know what did he rely on and how strongly does it support his conclusion or not. So if we don't have that, we can't do that. And then what do? It's the commission that's got the burden of proof. So you kind of got to put the onus on them to prove that his conclusion was reasonable. And you can't do that if you don't have that information to put into the record. Seem to be potentially having maybe a little bit of success about muddying the waters about whether Mr. Devine is Marty Riggs, but without us being able to see any of the evidence that they're looking at in this hearing, it's really hard to say. So Yeah, little better day for Mr. Devine today. So we'll see what comes up next. These defense witnesses, I'm curious about. What are they going to establish as hack? I'm not sure. I don't know, but I'm curious. So with that, guys, thanks again for joining me. I will plan to be back soon with the next part of this hearing. There are a few more still to go. So for all that they're being optimistic about how quickly this is going to be wrapped up, it appears that that may apparently not be the case. I am very curious to see if Mr. Devine ends up testifying in all of this. So yeah, real back and forth process so far. We'll have to stay tuned to see who gets the advantage in the next stage of the hearing. So with that, guys, take care, and I'll see you next time.